in space norms, guidelines and authorization, and ITO filing procedure. For the same, the chair of the session, I would like to invite Dr. P.K. Jain, the Director, Program Management Authorization in Space. The moderator of the session, Mr. G.V. Ashok, Partner, Factum Law. And the panelist of this session, Mr. M.K. Pattanaik, Senior Deputy Wireless Advisor, WPC, and Ms. Seema, Jhingan, the Partner, LexCounsel, Law Offices. May I have the chair, the moderator, and the members of the discussion so that we can start with the session. Over to you, Chair. We can start with the session. No, we can start with the session.
Okay, good afternoon to all of you, and welcome again back to this new session. On streamlining space operations. And first of all, let me thank SIA-INDIA for providing this opportunity to us to make this wide audience aware of the nuances of the norms, guidelines and procedures in respect of authorization of space activity, which we recently brought out. A task which we have been doing actually in various forums, and of course with one-to-one discussions also. And I will be more than pleased to provide a clarification if any, and also take note of any suggestions come in respect of this NGP on behalf of InSpace. So very quickly I will move to the couple of minutes I will take to provide the InSpace overview. Of course, morning Chairman InSpace touched upon some of the things. We had the InSpace was constituted subsequent to the space sector reforms announced by the Government of India in 2021, and we had the inauguration of InSpace headquarters at Ahmedabad by Honorable Prime Minister of India, and since then we have been witnessing a lot of activities in the India space sector. InSpace was given a very unique dual role in the sense that it not only acts as a promoter and enabler in terms of providing the pricing support, funding, or even doing the outreach, industry outreach or international academia outreach, but also we also act as a authorizer and supervisor for the various space activities in the country. When it comes to the role of enabler, the important thing is to make accessible the ISRO technologies, the ISRO infrastructure to the non-government entities. We also are working with various state government to build up the manufacturing clusters, and also creating some of the exclusive technical infrastructure with government funding by InSpace exclusively for the non-government entities. See some of the funding schemes I have not elaborated here, but we have come out with various price supporting the funding schemes for the startups, micro and small industries. We have recently brought out a decadal vision, which Dr. Goenka talked about in the morning, and we have started now working on the action points and implementing. I think that we have one exclusive session on this decadal vision. Recently, and we have, of course, played a key role within the Department of Space and within the government to bring out the much talked Indian space policy, as well as the FDI policy, revised FDI policy in the space sector. And recently we have released the NGP, which we are now discussing in this particular session. Now, the statistics in this slide are the testimony to the growing interest by the industry in Indian space sector. Now you see that more than 500 applications have been now being processed by InSpace. And if you see the category, it is starting from the seeking the ISRO support, either technology transfer or the usage of the ISRO facility, to the authorization, and the touching upon almost all the verticals of space area or space domain, again starting from the launch vehicle or the satellite or the downstream applications. And the applicants are represented in the entire spectrum of the industry, again starting startup or the MSMEs or the big industries. And we have also of course started issuing the authorizations, about to touch 50 authorizations in this last 2 years. Some of the major important authorizations, we have seen the activities in terms of activities, the suborbital launches by 2 Indian startups. We have seen the establishment of the Earth observation satellites, and also we have provisioned the capacity, SATCOM capacity, not only from the GSO satellite, but also from the NGSO LEO-MEO constellation. Indian space policy, again, it was launched 2023. Now, all of us know that it encompasses, again, all the areas of space domain and very clearly identifies the roles of all stakeholders, the non-government entities, ISRO, InSpace, NCIL, and Department of Space. And practically, it permits the non-government entities to take almost entire end-to-end space activities, starting from building rockets and satellite, launching them, setting up the launch ports, providing the services outside India, and do the data dissemination from the remote sensing satellite. So recently we brought out the norms, guidelines and procedures for the implementation of the Indian space policy. It's a very comprehensive 147-page document which addresses all the aspects of the authorization. It has the list of all the space activities which need the authorization, provides the criteria for granting authorization, what is the process, what are the different conditions or guidelines, and to the extent that we have also provided the template application form authorization certificate, which provides a clarity to the applicant that what type of information would be looked at. We had a wide consultation, in fact 2 rounds of consultation with industry while formulating these NGP. We had the multiple interactions with various government departments, took also the legal vetting, not only from the legal experts, but also from the Ministry of Law and Justice. And finally, the NGP was approved by the InSpace board. The NGP, if we look at, it addresses the who needs authorization, who can apply for the authorization. Of course, it is the Indian entities which are permitted to apply for the authorization. And it also addresses the various considerations and the provisions starting from the ownership and the management and control and the equity pattern of the applicant company, the criminal antecedent class, and also the adherence to various international treaties, accords towards the third-party liability or the for having the safe and sustainable space operations, the security safety guidelines, and so on. We have also brought out a separate chapters on the third-party liability guidelines. Of course, we are still working on that, and we will be shortly bringing more detailed guidelines on the third-party liability, the registration of the space object, what type of information which we are looking at, what are the best practices or guidelines to the industry when they bring up their satellites or the launch vehicle, and the ITU filing. Now, this is the first time again that when we have enabled the ITU filings by the non-government entities. As you know, so far ISRO was making the ITU filing. We have brought out those guidelines, and also the important thing is that the accessing the Indian orbital resources to the non-government entities, and a separate chapter on the NGP describe the procedures for that. When it the NGP also provides the details of the various categories of authorization, be it establishment and operation of the space object, be it again whether communication or remote sensing satellite or amateur satellite, operation of a space transportation system, and of course the dissemination of Earth observation data and the other space activities. The authorization process is very simple. Simple, of course, as far as the applicant is concerned, but we do of course a lot of due diligence. But the application can be submitted online on the InSpace digital platform. We have our own website. We carry out the preliminary assessment. Basically, also look at the credentials and the technical and financial managerial capability of the applicant, provide the acknowledgement to the applicant once the application is accepted, and then after the scrutiny of application, we also issue the advisory note in case the applicant is required to make either ITU filing or obtain the SCOMET license for exporting the satellite for the outside launch. So in parallel, the other process, the approvals from the other government departments are facilitated through this advisory note, and finally we either issue the authorization or reject. Of course, so far we have not rejected any authorization. The criteria, if we look at the starting from applicant credentials, the shareholding pattern, the safety, national security, the international relations or geopolitical considerations, and compliance to the various regulatory processes, spectrum, interferences, third-party liability, and so on. When it comes to timeline, we take, or rather we attempt to provide the authorization from ranging from 75 days to 120 days, depending on the type of application. The applications which do not require the interministerial consultation or which are reviewed within InSpace, we provide the maximum time. We take 75 days. The applications such as from the government organization or the ISRO launches or ISRO missions, we authorize very quickly. Some of the application which required the limited scrutiny by some of the other government departments, we take 90 days, and when it is requires the scrutiny by the various other departments, maximum 120 days. But again, one important thing here is that T0 is the start from the receipt of the complete information, and what we have observed here is that we do not receive the complete information at one go. So probably if some of my industry friends who are looking for the seeking authorization from InSpace, my suggestion would be that please go through the application form in minute details and provide as much as information as possible so that to avoid the iterations and then which delays the entire process. Coming very specific to the authorization for the SATCOM area, two types of major authorizations which are come under this category, and the one is the establishment and operation of the Indian satellite. It could be using Indian orbital resource, or it could be non-Indian orbital resources, could be GSO satellite, or could be NGSO satellite. And the second category of authorization is for provisioning the capacity of the non-Indian satellite or constellation to provide or enabling the communication services in India. One important thing which we would like to point out here is that the existing agreement, lease agreement from this non-Indian capacity, satellite capacity, which are either involving ancillary antrics or in C-band case where the direct lease was permitted so far, it is now valid only till March 31st, 2025, as is mentioned already in our NGP, and it is expected that the continuation of these services would require the in-space authorization again before this March 31st, 2025. And we urge such satellite operators who are providing these services to approach in space and seek the authorization for the satellite. One very important thing here is that the change which we have brought out in the recent NGP is that the service provider or the end user need not take any approval from the government, either from INSpace or DOS, which was the earlier case, and it is the one-time authorization we are giving to a satellite capacity, either the non-Indian or Indian satellite, and afterwards the users or service providers are free to take the capacity from any of the satellite which are authorized satellite, and the capacity can be even subleased or the resold also to any third party. So this is one important change. When it comes to the Indian satellite, now some of the conditions are with respect to the TT&C and the Mission Control Center. At least one Mission Control Center has to be there in India, but TT&C is can be the outside India also. This is another significant change with respect to the 1997 SATCOM policy or the 2000 NGP, wherein the TTC was to be in India. Satellite has to be registered as an Indian space object, and the validity of authorization is till the end of the operational life. This is again the difference with respect to the authorization of non-Indian satellite, which would be authorized only for the period of 5 years, and we will once again review the authorization. However, if the satellite, non-Indian satellite operates under Indian ITU filing as an incentive, we can consider the authorization till the end of operational life of the satellite. Some of the important criteria which while we see the authorization, while processing the authorization, is the interference-free operations of all the satellite networks which are being served by the existing Indian as well as the non-Indian satellites. And to that effect, we also advise that all the satellite operators to collaborate and negotiate to enter into either frequency coordination or the coexistence arrangement among themselves. In order to ensure the interference-free operations of all the networks. We also are permitting now the in-orbit procurement or acquisition of the satellite, of course with the prior authorization from INSpace. As I mentioned, the capacity can be further provisioned through lease or sublease to the third parties, which so far was not permitted. And we are also according the priority in processing the authorization for the non-Indian satellite capacity who are willing to operate under Indian ITU filing. Two important points here. we have taken now initiative in order to bring up the potential Indian satellite operator to provide the access to some of the unutilized or under-processed Indian orbital resources, either Indian ITU filing or the allotted orbit resources to non-government entities through an announcement of opportunity. And of course, all these things we are doing closely with WPC and DOT, and this is what where the access of Indian orbital resources is made to NGs. Now, if any non-government entity is desiring to establish their own satellite, there are two ways where they can have the access to the orbital resource. One is that we are facilitating the making the new Indian ITU filing, and therein the procedure is very fairly simple. It is already put in the NGP. Application has to put up on the IDP to INSpace, and we issue, after the preliminary examination of the application, we issue an advisory note to the NGE, with which that advisory note, the NGE approaches the WPC and applies for the ITU filing along with the ITU filing in the stipulated format. DOT is in the meantime separately bringing out its own guidelines, detailed guidelines and the procedure for making those ITU filing, but in the meantime the work has not stopped. The ITU filings are being permitted to the non-government entities. In fact, we have made quite a number of ITU filing. Another important thing is the applicant who is making the Indian ITU filing enjoys the rights of use of that particular assignment of the orbit spectrum resources pertaining to that filing, as long as he wish or as long as he operate the satellite there and use this orbit spectrum resources. And of course, we have also provision to suspend the particular satellite network assignment in case the applicant is not able to bring up the satellite in time, and even the permitting the relinquish or surrender of the transfer the ITU filing to the other third party, of course with the approval of the INSpace. This is again to encourage the more and more ITU filings by the non-government entities, so that the country acquires the adequate orbit spectrum resources. Another important thing is that the second way of making the Indian orbital resources accessible to the NGEs, we have also decided to issue the announcement of opportunity for the unutilized ITU filing or orbital resources to the NGs. The mechanism, detailed terms and conditions are given already in the NGP. Important thing is here only the entities with have the Indian management and control are eligible for taking these ITU filings. Announcement opportunity will be very transparent in the sense that the predefined selection criteria as well as the application of that selection criteria would be brought out in the announcement of opportunity. And again, like the case of Indian ITU filing, making new Indian ITU filing, the beneficiary would enjoy the rights of use as long as it operates a satellite, and they are also free to relinquish or surrender or seek the suspension. Of course, the important thing here is that they cannot transfer or sublet this ITU filing, which is availed by them through announcement of opportunity, unlike when they make the new Indian ITU filing. And of course, entire thing is with close coordination with WPC, DOT, as well as ISRO, because ISRO, for those filing which they have made, and if those filing, ISRO is evaluating whether they can be made available to the NGEs. So with this, thank you very much. This was the brief of the entire NGP where we can have the today discussion. And now I hand over the dais to our moderator, Mr. Ashok GB.
Thank you, Dr. Jain. I think we have the significant benefit of having two of the representatives from the regulatory bodies. So I think in the interest of ensuring that we are able to get their insights the most, I'll hand over the platform to Mr. Pattanaik, who can probably introduce his opening remarks.
Thank you, Mr. Ashok. I saw that there was some echo, and I hope we are all able to understand what each other speaks. So my presentation. Is it sure you're putting the updated presentation? No, that's okay. But I think I had shared a presentation yesterday. That was another presentation, not this one. Anyway, we will manage with this. So, ladies and gentlemen, my name is M.K. Pattanaik. I work in the Wireless Planning and the Coordination Wing, which Dr. Jain referred to as WPC. Wireless Planning and the Coordination Wing is the spectrum management agency of the country. It was established in the year 1952. And the purpose why it was established in 1952 was that there was a realization that at the ITU forum, there should be a specialized agency who represents India connected to the spectrum related issues. So today we have grown and we manage the entire radio spectrum for the country. But one of our prized activity, which I have stated at para 5, is notifying administration. We act as the notifying administration for India for recording Indian frequency assignments in the ITU's master register, or called the ITU's Master International Frequency Register. This is one of the important work that we do. Wireless Planning and the Coordination Wing. There are so many other things we do. We manage the terrestrial spectrum. We manage the spectrum used for satellite services. And you must appreciate that this spectrum is the same often it is the same spectrum is used for both terrestrial as well as satellite communication. So this is what we do. We do basically two kinds of activities when it comes to spectrum management. One is the spectrum assignment at the ground segment, that when the users finally get a spectrum, and the second part is dealing with the ITU as per the satellite filing is concerned. That way we act as the gateway for the ITUR activities. So before I take you further to my lecture, or what we do finally in WPC wing, let us briefly understand the legal framework of ITU. So legal framework of ITU is based on basically the Constitution, the Convention, and the administrative regulation. So the Constitution basically is a text which has evolved over at least 120 years, and today it has the objective to facilitating peaceful international cooperation, and fostering social and economic development through efficient telecommunication services. This is the main objective. It is complemented by something called the Convention, and then we have got administrative regulations, two of them. One of them is the radio regulation, which pertains to the radio communication sector. Another is the international telecommunication regulations, which pertains to the technology sector, T sector, standardization sector. Sorry. So the purpose of the union, so as I said, there are three premises or three pillars. One was the Constitution, another is the Convention, and the third one was the administrative publications. And in the ITU Constitution, it defines one of the most important things that it deals with: control of interference among nations. If I am using certain frequency X and another country uses another certain same frequency X, there has to be a compatibility between these two. That is the main purpose. And if you look at the purposes of the union and harmful interference, this theme, this central idea repeats itself with regular monotonicity, you would see. And then in Article 44, it deals with something we call as the equitable access of spectrum, which has become a hot topic internationally. This is one of the agenda items in WRC 27 also. So this is the radio regulation. I do not want to dwell on each slide for very long, considering that we want to devote some time for the question answer session also. So radio regulation, for those who are not familiar with this book, it's an international treaty, and so it is binding on all the member countries. Secondly, it defines the right and obligation of member states in respect of the spectrum resources. And the third point is what Mr. Jain repeatedly emphasized: entry into MIFR, recording a frequency assignment in the Master International Frequency Register. This is also something that is governed by the provision of the radio regulation. And I again draw back your attention. What is radio regulation? It is an administrative publication of the ITU. So it is again complemented by another book called the Rules of Procedure, and it is updated every 4 years at the WRC. So once again, to recapitulate, there are 5 different ways how the interference is controlled. One is allocation, another is power limits control, another is the coordination, mark the words coordination. I'll come back to that in a moment, because a lot of things depends, when we come to the space sector, a lot of things depends how effectively our industry is able to coordinate internationally their frequency. And then recording the international rights and obligation flows. Then we have got monitoring. We have got a monitoring organization. It's a quite elaborate elaborate setup. And so these are the 5 pillars of international spectrum regulations. Next, I say in MIFR, I try to capture those central points, central ideas in this slide. I give you 15 seconds to just go through it. I will not describe it, but on the right side, if you see, what are the ratio of GSO versus NGSO satellites presently. So we go to the next slide. So as we understood now that MIFR entry gives you certain privileges, certain rights. What are these rights? These rights are that it gets an international recognition. That means anyone who comes after you must coordinate with you, must respect your right. He must see that his network doesn't interfere with yours. He must check that he doesn't get an interference from your network and later on complains that no, you see, I'm in dire straits now. So at the stage of coordination, these things are taken care of. So entering into the MIFR is not a straightforward method, straightforward thing. It requires that you do certain activities, and these activities, once you fulfill those activities, then only you become eligible to enter your assignment into the MIFR. What are they? There are quite a few. It depends from one application to another, but basically the first thing is that there is a regulatory time frame. Within 7 years, you need to complete it. 7 years. If you do not do it in 7 years, go back and start the cycle again. Very costly proposition. So 7 years time, we have to organize our activities in such a way that we do it in 7 years. 7 years counted from a date called the date, a firm date of receipt by the ITUR of a request for coordination. From that day, you count 7 years. So then there is something called administrative. So at point number 3, I have marked in blue because this is the most time consuming and it is the most important activity that you must complete or you must do, attempt, did not complete it, but you must prove that you have done enough to get international coordination. That is point number 3, most important thing. And so this is ITU regulatory procedure. I'll only say in 1 minute what it means. It has got 2 parts. On the top part, you have got something, if you look at the blue box on the left side of the screen, then it says that submission of the API info. On the bottom part, it says submission of the coordination information. This is meant for two different kind of networks. So they have different kind of procedures. API is a relatively simple procedure, whereas coordination is a relatively lengthy procedure. And it takes 7 years for something called the non-planned services, and for planned services, it takes 8 years. Again, this kind of, I'll not deal much time on this slide because I have more or less explained what it means. So I would say that what are the planned services versus non-planned services? There is a lot of confusion. Pay attention carefully. What is a planned service? What is a non-planned service? I mean, don't go into the complexities of the plans, the slots, and all that. Put simply, for all practical purposes, planned services are those in which you have got a right to ask for a service area exclusion. You can say that, you see, Australia, UK, Germany, whoever, Pakistan, China, whoever puts a satellite on that frequency band, I can always claim that do not use my service area, exclude my country from the service area of your. It's not something called a first come first served kind of thing. Whereas in a non-plan, you do not have that privilege. Anyone who comes first, he gets a first right to use. You cannot say a service area exclusion unless you have an existing use in that, on that particular use. Supposing country X puts a satellite and shows that your country is covered, it can provide a service on that. But you already have a terrestrial application running on that frequency. In that case, you can always raise an objection, provided that terrestrial service running in your country is already registered, already notified in the MIFR. MIFR notification is something which is crucial when it comes to international enforcement of rights and obligations. So we in WPC wing do all kind of filings for you, and when you submit your first notification, first coordination request, we send it to the we send it to the ITU. ITU examines it, and if finds it okay in all respects, then it establishes something called the form date of receipt. And from that day, the regulatory clock begins, it starts. If not, it returns it to you through the administration, and we are supposed to again reply to them, correcting the errors. But unless we establish, unless we give them all the information required, then they will not set up something called the form date of receipt, and the more delay happens, the more coordination burden increases on you. So it is necessary that once you decide that we do go ahead and do a filing, do not delay, friends, because every day, every passing month, these geostationary orbit and resources are getting more and more crowded, are getting more and more occupied, and so if you do delay, then you will be coordinating and asking permission from those people who were earlier to you. So this is what was, and this is something, I am coming to the last of my slides. It has generated enormous interest in the last few years, something called the short duration mission. Short duration mission are all those satellites which are launched by the small satellites, the CubeSats, and so there is confusion, and a lot of people ask what are they, universities they ask, and they whether we should notify it, whether we should not notify it, a lot of questions asked. So there is Resolution 32, which was passed in WRC 19, and it has 4 points basically. First point is that these frequency bands must not be subject to coordination. It must follow a API procedure. Second is that the total number of satellites should not be more than 10. Generally, all your universities, educational institutions, they all have less than 10 satellites. Then the period of validity is always less than 3 years. You cannot go beyond more than 3 years. Because and there is no scope of any renewal also, and it should have a capacity to stop transmitting immediately in order to control the harmful interference. And so this is the basic thing of short duration mission. And if you are an amateur and if you want to use the amateur band for satellite, then you can do it without any cost. You can do it free of charge. So all these small satellite, all these people who are facilitating universities, colleges, trials using the amateur band must take advantage of it. That's my understanding. There is another good thing about this short duration motion is that there is a frequency band 137 megahertz, which is used for TTC, which we call the space operation function. And this frequency, although in other applications this is a charged frequency, satellite ITU charges for this frequency. When you use it for a short duration motion, it is not charged. So these are some of the useful links that you will find useful to how the satellite communicates, and there is a e-submission portal. A lot of things happens on electronic means, and you can submit your application online. And then there is the e-communication. When the satellite ITU wants to convey certain information to you, then it comes to the e-communication procedure. And this perhaps is my last slide, and which talks about a little about cost recovery. All of you must realize that WPC wing until now hasn't been charging anything to process your satellite filing, but ITU does impose a cost on you. ITU imposes a cost, and this cost varies depending on the complexity of the network. If your network has more number of beams, more number of different kind of R stations, different kind of emissions, in that case the charges increase. And so to give you an idea, the API, as I said, there are two procedures. One is API, another is the coordination procedure. The API fee is for 570 Swiss francs. Then notification fee comes to 7,030 Swiss francs. And then those who are subject to coordination, if you look at the right column, then we have got the coordination request fee, which can range from 5K to 66K, depending on how complex your satellite system is. And then there is a notification fee, which can vary from 15,000 Swiss francs to 86,000 Swiss francs. So this is how it happens. But there is one thing that you must be careful, that once you submit a filing, if you withdraw it within 1 month, then you don't have to pay the charges. But if you do not withdraw it within 1 month, then the charges apply. If you withdraw after 1 month, saying that now you see I don't have this thing, I don't have to pay, that doesn't sell, it doesn't wash. Given that, you must be very sure what you are doing, because money is involved, and as such, government cannot pay for a misunderstanding. So this is kind of my slide, my presentation. I have used many of the slides from ITU and internationally available resources. They are not mine, so all the credit goes to them. Thank you very much, ladies and gentlemen, for your attention. Thank you so much.
Thank you, Mr. Pattanaik, for the very detailed presentation. Ms. Seema, opening remarks, quick five minutes, perhaps?
You can ask me the question.
Okay, perfect. So thank you. So I think we'll quickly jump to the Q&A, because I think for all of us, the policy on paper has been a very exciting development.
Ask me the question.
So it's been a very exciting development, but I think my endeavor is also to try and go between the lines to see, what actually is underneath the policy. Ms. Seema, I'll start with you first. I think there's been a great deal of excitement ever since the NGP came out. But I think for a lot of us lawyers, the question that always arises is the legislation, the administrative law foundations of it. So would you want to briefly reflect on the NGP, the source of law, any concerns that the legal fraternity has had in terms of the structuring of the regulations itself?
So thank you for your patience. See, instead of going into the the legal issues related to the policy, which Dr. Jain has already gone into a lot. I think what I will go into is, we have understood the broad perspective of the policy, but let us understand in a very brief manner what it does mean for me as a space entrepreneur. What does it mean for me in these 147 pages? What do I need to do? And I think Pranav had raised this issue in the last panel, that whether we have gone from no license to a license Raj bringing in this policy, and he's rightly answered it with the absolute no. And the reason for this is that prior to this policy, it was not that the space entrepreneurs could have done they could have set up satellite system or Indian satellite operations or done anything with respect to space. It was not an unregulated sector. And there was a black hole out there. So when I've been practicing in the space law for the last 25 years, and I see some veterans, Raghudas is here, who's been here doing space law, and he's a veteran in space industry, who have been trying to knock the doors of ISRO for last 25 years to get us the approvals, whether it was to set up the Indian satellite systems or to channelize the foreign satellite operations into India, or even to canalize the foreign capacity into India. It was an uphill task, and it became more and more difficult as we approached 2013 after what happened after Devas. So this policy has actually brought predictability to the regulatory regime. This policy has brought some transparency, and it has given the space entrepreneurs who's putting in time and energy to bring into fructification their projects some roadmap what is needed. So now let's look at the legal nuances. I'm not going to tell you about the policy in a broad perspective, but what does it mean when I'm a space entrepreneur? What does this policy entail when I have passed through the authorization? Once I have the authorization, what are my legal obligations, and what are the things that I need to be extremely careful? They're spread across the policy, but I've just picked up some of those crucial points, and the issues that the authorized applicants are facing. So first of all, we have to understand that this policy is not in derogation of other rules and regulation, as Mr. Jain has said. It is in addition to the norms that an entrepreneur has to. So if he is in the domain of DOT licensing, he will continue to operate with the DOT licenses and also comply with policy authorization. It's not in derogation. Number two is the space authorization that you get is specific to the space activity that you'd applied for. It's not generic. You can't launch 15 different space activity objects based under one authorization. It's specific to that authorization for the plan that you had submitted. The third is it is non-transferable. So you cannot now decide, oh, this is too much for me. Now let me transfer this authorization to somebody else. This doesn't happen. You need to take a prior approval from the government, which is in space, to transfer it. And why is that required? Because when the authorization was originally given, they had looked at your technical capabilities, your financial credibilities, and your reputational risk that country can have by giving you the authorization. So what is needed is when any transfer happens, that transfer has to be with prior approval. Then any deviation from your space activity, you have applied a plan to the in space, you've got an approval for that activity, you cannot randomly change your activity and say, now I'm going to do something else, or within the four corners I'll change it. As long as it is not interfering with other space activity, some contouring may be allowed. But if you're changing you're pivoting or you're changing the direction of your space activity operations, you need to another approval from the government. A very interesting concept has been brought in the policy, which is that if you are doing any if there is any criminal activity lodged against you, so you're operating a space as a space entrepreneur, if there is any criminal activity or a case or a FIR or an allegation under the Indian Penal Code or under the Prevention of Money Laundering Act or other Official Secret Act has been launched against you, you are supposed to inform in space. So this is an obligation on you as a space entrepreneur. They may not ever come to know, but you're supposed to inform. Now the pitfall of the information is that InSpace has the right to revoke your authorization, see the impact of that allegation into your ability to operate the space activity. They have all of that power. The other thing is that this particular authorization came to you with your company structure. You cannot change it without prior authorization. In the sense, when I said you don't have to take prior authorization, but you have to, within 48 hours, you have to inform if there is a change in the management and control or any change in the shareholding. Now, this is not qualified. That if you see the policy, it says any change in management and control, which is a defined term, and I'll come in a bit on what is the management and what is control. But it also says and shareholding pattern. Now, shareholding pattern, and I would request Dr. Jain also to sort of bring more clarity to it. If I'm changing 5% of my shareholding pattern, that's not change of control. Why should then I should be required as a space entrepreneur to sort of intimate that change in shareholding? But if there is any change in from Indian to non-Indian, if any foreign entity is being brought up in the your company, that also needs to be informed. So management, when this is management, change in management means if you're also changing your CEO, your CFO, your whole-time director. So even the critical positions in your company who have the power to have impact on your policies, have the power of changing the direction of your company, and if there is any change in those positions, you need to intimate the government, and they have the power to sort of look into it and possibly maybe suspend. They have the power. I'm sure they do not do that in such situations, to change and revoke your authorization. The other thing is that you have an obligation as a space entrepreneur to mitigate any space debris. And as Dr. Somnath has recently said that we will be coming up with a debris-free space mission by 2030, the obligation is again put on the space entrepreneur to minimize and mitigate any kind of space debris that we will be creating as space after the launch of the space objects. The other implications that was also dealt by Dr. Jain is that there are third-party obligations. Now, Indian government as an Indian administration has an absolute liability for any damage that happens on the earth, surface of the earth, or in air, and fault-based liability when it comes to outer space, which basically means whether I launch the satellite or ISRO launched the satellite, and if there is a potential damage or an actual damage which happens, then the government of India is liable under the international liability conventions. So in that sphere, Dr. Jain had mentioned that third-party liability policies will be brought in, and we have to take all steps that we do not expose the government. So as a space entrepreneur, I'm a very small space entrepreneur, I have a larger obligation not to expose the government of India to any kind of liabilities that they may incur against the under the liability conventions. And I have the obligation to then indemnify and be liable for the damages and the penalties that the government will invoke on me. So these are some of the action plans that as a space entrepreneur. One additional thing I would like to bring in is the fact that you cannot, once you've taken the authorization and you've launched your services, you cannot just pull the plug out because there are users, the authorization have been given. You need to give 30, 60 and 120 days of notice for even suspension. So it depends on the activity that you're doing, but you need to give a notice for suspension or even termination of the authorization activities, which basically means that if you do that, what if I do that, then the government has the power not to accept your suspension, terminate the authorization that you are yourself wanting to terminate, and impose penalty on you. So these are the obligations that we do not consider. When we, as an entrepreneur, when I advise clients, they're very happy to get the authorization and look at the commercial side of it and the operation side of it, which obviously is important. The ROIs are all important, but these are the legal implications that we sometimes out of oversight we just forget, and these are the important areas that we need to be looking at. The other aspect is, what are the powers of the government? I think that could be a second question to that.
So a very, very quick follow-up. Do we still need a legislation or not?
So we have as a lawyer, we have an interesting situation where you have a policy, but there's no overarching space activity legislation here. So in 2018, we had a space object bill that was brought in. There were a lot of issues. It was in coordination with Nalsar University, if I'm not wrong. A lot of discussions and debate happened on that bill, and there were a lot of loopholes on the way and the manner that space object bill was brought in. So we do not have the legislation right now. Now we have the policy. Now the question that I think you're hinting is this even policy enforceable? Whether this policy stands in a limbo without any overarching law. Well, from a legal standpoint, the policy is there without the legislation, but once you get the authorization, you sign on an authorization dotted line, which has all the norms. And if you're accepting the license, you have to accept the policy requirements, and which basically means what? You get governed by three things: liability obligations, authorization norms and adherence to authorization norms, and third is adherence to the arbitration clause. Now there is all the disputes are going to be subject to Indian laws, and there is an arbitration clause in the space policy which otherwise stands as a standalone clause, but once you sign the authorization letter, the entire dispute resolution, suppose you get invoked in a penalty and there are $1 million of exposure to you as an entrepreneur, you can litigate against InSpace and Government of India under an arbitration, but the arbitration can only be governed in Ahmedabad, where the InSpace headquarters is.
Thank you, ma'am. Dr. Jain, now over to you. I think whenever there are norms or policies that come out, and especially as comprehensive as the ones that's come out, one of the concerns is the extent of freedom of business and governmental interventions. So on the subject of frequency coordination, I do see that in the norms there is mention of InSpace undertaking appropriate and enforceable interventions in the context of frequency coordination arrangements. What are the likely scenarios in which InSpace may look at undertaking this appropriate and enforceable interventions? If you can throw some light on that.
Yeah, thank you, Ashok, for this question. So, see, this is all the enabling provision. What is the idea basically when we accommodate and provide the authorization for various satellite networks and various satellites, be it Indian or non-Indian? Ultimately, they have to operate in the interference-free environment. So the new authorization, any new entrant should not impact the services of other satellite network which are already operational. So that is the idea, and this is accepted norms even in the international or any national regulatory provision, where either you bound by the frequency coordination agreement, or you so that there is no interference. What we have even relaxed to that extent that we are not insisting that it has to be a frequency coordination agreement. Even there could be a coexistence arrangement, some sort of understanding between the various satellite operators, so that everyone understands the impact, and then everyone operates without any harmful interference. As long as that is there, we are not worried. We finally want to ensure the interference. But in case there are certain the complaints saying that the other one is not cooperating, so there is no question of any priority, non-priority here. That's what we are told very clearly. Ultimately, everyone has been authorized, everyone is operating. It should not happen that I am the first entrant, though I am not the senior in the ITU Parley, but even then I don't have any obligation to coordinate. And that is the idea which is generally worldwide it is being practiced. And our intervention would be only to the extent either we can ask the particular, after of course going through and doing the due diligence, once we are convinced that one party is not collaborating or blocking the other one, then probably we will make the intervention to asking it to switch off the particular network or emission.
Thank you, Dr. Jain. A quick follow-up question. I think one of the exciting developments for lawyers especially has been the liberalization of the foreign direct investment into the space sector. Pretty much 100% is open either under governmental route or through the automatic route. Now, one concern that emerges is the use of the phrase Indian management and control for certain kinds of activities. For example, announcement of opportunity, you do see that there is preference to Indian management and control. So the question then arises, will the FDI vision be realized fully, given that certain avenues are open only to Indian managed and Indian controlled entities? Your thoughts on that, sir?
So there are two different aspects. See, the 100% FDI is always we have permitted, and it is welcome, so that we are permitting now the non-Indian satellites as well as the non-Indian players to come and then do the space activity in India. The provision which you are talking about is for making available the Indian orbital resources to the Indian private entities. Now, it is the orbital resources which are either in the process of acquisition by the Indian administration, and naturally what is the consideration is that what government wants, it is not only the permitting, of course, the non-Indian satellite, but also we have to bring up and the potential Indian satellite operators. And the orbit spectrum resources being a very precious resource, and we all understand that is the major actually hurdle in bringing up our own satellite. And in India right now we have only the ISRO or the ANSIL, which are the Indian satellite operator. And this orbit spectrum resource being the major link, this is what is the proactive measure which government has come up, and within a view to bring up some more potential Indian satellite operator by making them available this Indian ITU filing. But it does not mean that the non-Indian players are not permitted. Non-Indian orbital resources are being permitted. The Indian satellite can use both Indian as well as non-Indian orbital resources.
Perfect. So I think I probably have time for just one more question, which I want to take the opportunity to bring to Mr. Pattanaik. Mr. Pattanaik, you spoke extensively on the ITU procedures and protocols. Now, one of the things about the norms that I find interesting is the usage of non-Indian orbital resource. There's a requirement, for example, to bring it under Indian administrative control at some point of time. How easy or feasible is it to bring a non-Indian orbital resource under Indian administrative control?
I think you really brought the elephant into the room. If you look at the ITU website, until in the history of satellite communication and filing, how many such things have happened? The number doesn't increase, doesn't go beyond 20 or 25. Is that instructive? Does it say something? The number of changes that has happened, how they have happened. There is a possibility that one administration becomes the notifying administration for a group of administration. For example, Africa. 4 countries can get one satellite filing and they take the service from that. And supposing one of the countries act as a notifying administration, after 3 years, another country of these 4 becomes the notifying administration. Another one which has changed is between UK and US. That was in Inmarsat, if I remember. That is available on the ITU website. So here also they have a joint interest in this satellite filing, and UK relinquished this and US took it over. That was one of the cases. This is a new experiment. I would not be able to make a judgment that finally what will be the yield, what will be the output. But this is something, yes, let us wait and watch. It may require some policy change, policy modification. As we move forward, we can always change it, but right now it stays. And second point is, it's a very complex question, sir. It will take me 2-3 minutes to answer that. But I will not say much because I will not say anything that the government of India has decided. But sir, I would make 2 points here. First point was about Madam Seema. She made a point about space debris. Some countries who have sent thousands of satellites I think the first onus of space debris control rests on them, not on countries like India. There are countries, administrations who have sent thousands of satellites. One country sent 43,000. And our satellite filing is not more than even 500, 300, 400. I think these countries must be, first answerability must lie with them. And WRC 27 rightly recognizes space sustainability. And who is at the receiving end? I'm not scared there. I'm not worried. I have very few satellites, I can control them. The onus lies on those big constellations who are flooding the sky. And that is the point that I wanted to clarify. But the second point, yes, I think it's a good thing. It looks good that we have certain thing under Indian management and control. And anyone who is desirous to provide service in India should have an Indian filing. But it should not restrict competition in the market. It should not restrict that some players refrain from coming to India or providing their services. That way your availability will be less, the demand will be more, and the supply should not be less. It should not be restrictive. That's my understanding. However, it is subject to further clarification by the authors themselves. Thank you so much.
Thank you.
Sorry, Ashok, I think one small clarification I would like to add what Pattanaik ji has told. First of all, there is a lot of misconception. First of all, it is not a transfer of the filing or the arbit resources from one administration to other administration. If you are referring to the particular NGP, it's very clear. It is what we are trying to tell there is operating the satellite under the Indian ITU filing. It's not the transfer of the spectrum resources. So this is what Pattanaik ji told. It's a very rare thing happens and all that thing and all. It's no way related to that. Number one. Number two, about the Pattanaik Saab comment that it should not be restrictive, and it is not restrictive because this is only the providing the priority in the processing of the authorization. It is not a mandatory condition. So we have been providing the authorization to the non-Indian satellite capacity, of course, depending on the balance between the demand and supply. So these two things I thought I would just clarify.
Thank you, Dr. Jain, for the clarification. I think we are completely out of time. Can we take one question from the audience? Yeah. Any questions from the audience? If you could just raise your hand. I see.
Only if we are not overpowering their lunchtime.
My question actually is to the whole panel. First of all, I would like to compliment Dr. Jain and Mr. Pattanaik for the excellent and very unique insight they have given into the new space policy and the in-space. Actually, my concern now is that now that we are getting into a very, very big change in the entire operating environment, is there also a plan to create an infrastructure? I believe that we require a gigantic infrastructure to monitor, to be able to implement, and to be able to respond to a different, a range of complaints or.
Can you hold the mic closer to you? We are not able to hear you. Can you hold the mic closer?
Yeah. So what I'm saying is that is there any plan to also create a gigantic infrastructure to be able to understand, to be able to appreciate what kind of monitoring is required, what kind of complaints are handled, how they are handled, and the entire thing which goes with such a big initiative going into space. Are we trying to create something, or will the existing way of handling things would be able to manage that?
Understood. Given the paucity of time, I'll probably direct the questions to Dr. Jain.
Thank you for that question. It's a very pertinent question. So that we understand that as the activities, speech activities are growing in the country, there has to be a proper mechanism of the monitoring and supervising the entire activity. So, of course, the government has geared up. The various government departments, including the Department of Telecommunication or MIB or the InSpace or Department of Space, have been working on the respective mechanism. Of course, every department has its own mandate depending on the activity, type of activity. There are already the guidelines, there are regulations already in place. They have the respective monitoring mechanism, but we do acknowledge that we need to review, strengthen it further in view of the growing activities in the country, especially now the sector has been opened up to the private entities.
I'll just add to Dr. Jain. As a practicing lawyer, what I've seen in the last 30 years of my practice is that the biggest challenge is not, as you've mentioned, coming out of the policy. That's just the first step. The biggest challenge that we face in this country is the implementation of the policy, and most of the policies which are brought in good faith fail or are lacking in implementation is because they don't have the required infrastructure, the backbone, and most importantly, the training that is required to be given to the mid-level checkpoints for addressing any kind of needs and requirements of the applicants. And that is where we have struggled in the last almost 3 decades, which has improved significantly. And this particular policy and the way InSpace is available and addressing the questions, and they're available to address any questions that the applicants are asking, it's a significant change, as I have also seen, because the biggest issue is always in augmentation of the policy implementation, and that's the question. It's a very relevant issue that you've raised.
So I think we're completely out of time, so I'll have to bring this to a close. So I think the takeaway for me is that we have two regulators now coming forward and saying that we're open to questions, we're open to suggestions, and we will explain and work with you to try and make this actually work. That is the symptoms of a changing ecosystem and changing market landscape. So I think with that, I'll bring the session to an end. Thank you so much, all of you. Thank you, Dr. Jain. Thank you, Mr. Pattanaik. Thank you, Ms. Seema. I think this was a wonderful discussion. Thanks to all of you. Over to you, ma'am.
Indeed, a wonderful discussion. Thank you so very much. With this, we move on to the felicitation ceremony. May I request the chair, Dr. P.K. Jain, to kindly felicitate. We'll start with the moderator, Mr. G.V. Ashok. Then the panelist, Mr. Pattanaik. And Ms. Seema, the partner LexCounsel offices. May I call upon Sudeepta Behra, the Director, Communication, SIA, to kindly felicitate the Chair, Dr. P.K. Jain. And we can have a group picture as well. Thank you very much. With this, we come to the end of this session as well. It's time for the lunch break. Our post-lunch, we'll resume here sharp at 2:30 without any delay, so that